Hello, everyone. My name is Paige, and I am the Technical Assistance Manager with DC Safe. And today we're going to be talking about how a survivor can obtain a protection order in Washington, D.C. And what's important to note is that this process, in terms of obtaining a protection order, is different in every jurisdiction. So, this process that we're going to be talking about today is very specific to Washington, D.C. And a lot of the specifics are not going to be applicable even to our surrounding areas, including Virginia and Maryland. So let's get started. So our learning objectives. First, we're going to talk about who can actually apply for a protection order in Washington, D.C. There is a distinction in the district between a protection order and a restraining order. There are only certain types of relationships who qualify for a protection order, and it's specifically built for people experiencing domestic violence. So we are going to talk specifically about the protection order process. Everyone who does not qualify for this process can ask for a restraining order. It's a separate civil process, and that's important to note. We're also going to talk about what protections are offered through the temporary and civil protection order processes. Why would someone want to go through this process? What can the courts remand the respondent to do, or the abuser? What can they enforce? And the third is we're going to become familiar with the actual process. What steps does a survivor need to take in order to obtain either a temporary and or a civil protection order? So first, let's talk about some important terminology. Temporary protection orders, or TPOs, those are 2-week orders that are granted by a judge in what's called an ex parte hearing, meaning that it's only the petitioner who is present for that hearing. The respondent is not present. And those TPOs are generally issued for no more than 2 weeks unless the respondent has accepted a longer temporary protection order. And we'll talk more about that later. But typically, a temporary protection order is a short-term protection order. Whereas in DC, a civil protection order can last up to a year and is renewable. At those hearings, both parties are able to be present. And there are more protections that are offered within the CPO process as compared to just with the TPO. There are more types of what we call relief, or things that a judge can enforce the respondent to do or to abstain from. The petitioner is the person who files for the petition, the person who is asking for protection from the court. The respondent is a person who is responding to the allegations that are listed inside of that petition. So often what we're talking about in our circumstances is a petitioner is someone who we would identify as a survivor, and the respondent is someone who we would identify as an abuser. Pro se, the protection order process is a pro se process, meaning that neither party, neither the petitioner nor the respondent, are guaranteed an attorney. And often we see that parties are representing themselves. They can either hire a paid attorney, paid legal representation, or they may qualify for a pro bono attorney, but I would say the vast majority of the clients that we work with represent themselves, so they are pro se. Ex parte refers particularly to the temporary protection order process. It's a hearing that's completed with only one of the parties present at the hearing. So in this case, at the temporary protection order hearing, only the petitioner is present. The respondent is not present. Ex parte hearings are typically only held when there's a possibility for irreparable harm. So if they were not able to have that temporary protection order process, the petitioner may be harmed in the interim 2 weeks between when you file the petition for the civil protection order and when you actually hear that hearing. Other important facts: civil court is a forum for private parties, meaning that the government does not have an interest in this. There are generally no government actors in a protection order case. It's very similar to things like landlord-tenant court or small claims court. It's where two parties can bring the case in front of a judge, and the judge is acting as a neutral party to make a decision based on the relevant laws around that topic. So in this case, the petitioner is bringing allegations against the respondent, and the judge is ultimately making the decisions as to whether or not they're going to issue that protection order. Again, no party is entitled to an attorney in civil court. Anyone, regardless of immigration status or citizenship status, can file for a protection order. Same with gender identity or sexual orientation. Folks of all genders and all sexual orientations can file for protection orders. And there is not a filing fee for a civil protection order. And this is also another distinction from the restraining order process. So there is no filing fee for a civil protection order. There is a $160 fee to file for a restraining order. So people who do not qualify for this process can file for the restraining order, but there is a filing fee. People can ask for waivers if they are unable to pay, but other than that, it is a free process. The civil protection order process is free for everyone who files. So what has to be true in order for someone to get granted a protection order? In DC, there are three main things that have to be true. The first is there has to be a specific type of relationship between the petitioner and the respondent. And in DC, we refer to that as an intra-family relationship. And we'll talk more specifically about who that is in just a second. The second thing is that the respondent has to have committed a crime against the petitioner. We'll talk about what crimes judges are typically looking for in just a few minutes. The third is jurisdiction. So the district has to have jurisdiction over this case. And for our purposes, that means that either the petitioner is a resident of DC, or the petitioner works or goes to school in DC, or at least one incident of violence listed in the petition has happened inside the district. So again, to repeat, there has to be an intrafamily relationship, there has to have been a crime committed, and there has to be jurisdiction in order for someone to get a protection order in DC. These are the different types of relationships that qualify under the Inter-Family Offenses Statute, and that's how we define domestic violence in the district. So folks who are related by blood, by legal custody, and this can be legal custody of a minor, this could be legal custody of a person with a disability, or this could be legal custody of an older adult, related by marriage, having a child in common, roommates, and really specifically we're looking at people who have shared amenities. So this could be group houses where there are shared bathrooms or where there are shared kitchens. We're not talking about people in the same apartment building, but very specifically people in the same residence. This was a big push particularly by the LGBTQ community so that people who were filing didn't have to out themselves in terms of being in a relationship with someone of the same gender, because the other thing to note is that all of this documentation is public. It's accessible to the public, and so they wanted to create a safe space for LGBTQ folks to file under a roommate statute, so they did not have to disclose their relationship. Dating or sexual relationships, for our purposes, this can be one date or one sexual encounter. Intimate partners, so spouses related by blood or marriage, any of those will qualify. Or people who have experienced sexual assault or stalking. All of these types of relationships qualify as an intrafamily relationship for the purposes of a protection order. In terms of age, for all minors, a parent or guardian can file a protection order on behalf of that minor. Starting at the age of 16, minors can file against any of those relationships that we just talked about without parental notification. They can file on their own starting at the age of 16. Starting at the age of 12, minors can file against intimate partners without parental notification. If they come in, though, the court may choose to appoint an attorney for the minor if the court deems it as necessary. Any minor younger than the age of 12 must have a parent or guardian file on their behalf. And the last thing to note is that parents cannot file against their minor children. Minor children can file against their parents, but it does not go the opposite way. So what is a criminal offense? In DC, common examples that we see are assault or attempted battery. It could be destruction of property, harming of pets, sexual abuse, arson, threats to harm or threats to kill someone. All of these are things that are considered crimes in the district. But what's most important to note is that when someone is filing for an alleged crime in a protection order, It does not have to have been reported to the police. There do not have to be any reports, any police reports, for someone to obtain a protection order. The judge is ultimately the one who's determining whether or not a crime has been committed. So when we talk to survivors, and if they've never called the police, they can still qualify for a protection order. So we're now going to go through the process of how you can actually get a protection order. You should have a copy of a flowchart for how to get a protection order. If you want, you can follow along with that. And we're going to go through what steps does a survivor have to take in order to get a protection order. The first thing is that they need to file a petition. There are two places that survivors can file for petitions for protection orders. One is inside the D.C. Superior Courthouse. The other is at United Medical Center, which is a hospital center in Southeast D.C. It's a satellite office for the courts. At the D.C. Superior Courthouse location, if the petitioner is related to the respondent because they've had a dating or sexual relationship, they have children in common, or the respondent has sexually assaulted or stalked them, they can go to Suite 4550. This is the office that SAFE staffs. So those are the populations that SAFE specifically works with. For anyone else that does not follow within that purview, they can do what's called a self-petition, meaning they can go directly to the clerk's office, which is in Suite 4510, and they can fill out their own petition for a protection order. They still have the right to get a protection order. They're just not going to have the enhanced services from DC SAFE's advocates. Same for United Medical Center. SAFE is also co-located there as well, but any of those relationship types can go to the UMC location and file for a protection order. It's on the administrative side of the building in room 311. What's important for us to disclose to survivors that these locations are not open 7 days a week. They're only open Monday through Friday from 8:30 a.m. until 4 p.m. And when someone comes to file for a civil protection order, typically the hearing will be set 2 weeks from the date that they file that initial petition. The last thing to note, and this is very important when we're talking to survivors, is that if they're coming to access the court process, all of the documentation has to be completed no later than 4 p.m. The clerk's office will not accept forms later than that 4 p.m. hours, so the earlier that they get there, the better. What I often tell survivors is that if they want to see a judge that same day, which we'll talk about in just a second, they need to block off at least 4 hours during that 8:30 to 4:30 time period because the wait can be very long in order to see a judge, particularly at that Southeast Center. The way the Southeast Center functions is that they satellite a judge in from the DC Superior Courthouse. And depending on how many people are filing at any given time, I've seen survivors come in at 8:30 in the morning and stay until 4 or 5 p.m. in the evening. So it's very important for us when we're talking with survivors to let them know that the earlier they can get there, the better, and the faster that they're going to be served. So what is a temporary protection order? When a survivor comes in, there is an example of a blank petition that you should have with you, and you can see what that petition looks like. And that petition covers both a temporary protection order and a civil protection order. So survivors do not have to recount all of the incidences of violence more than once. They can use that same form to file for both of these orders. A temporary protection order is put into place if someone wants to see a judge immediately. So the majority of the clients that we serve, the majority of people seeking protection orders, want some type of protection to be implemented immediately. They're coming because some type of a crisis has recently happened, and they need protection starting as soon as possible. So if they want protections to start as soon as possible, which can be as soon as that day, they can request a TPO hearing. At that TPO hearing, this is the ex parte hearing I was talking about. So it's only going to be the petitioner and the judge that are present during that hearing. The petitioner will appear before the judge. The judge is still going to go through those 3 requirements. They're still going to determine if there's jurisdiction, if there's an intrafamily relationship, and if a crime has happened. They then can choose to grant the temporary protection order or decline the protection order. And we'll talk a bit about what that means in just a second. If a protection order is granted, then there's some types of limited relief that can be granted. And relief is what we refer to as the types of protections that a judge can require a respondent to uphold. So that same day, if a person files for the temporary protection order and it's granted, there are 5 big categories of relief that can be granted within that temporary protection order. And this is a small sample of what can be granted within a civil protection order. And the reason there are so few things that are granted in this temporary order process, the respondent's not there. They don't have the option to refute the allegations that have been brought against them. So the judge doesn't want to limit their civil liberties more than they have to keep the petitioner safe. So they have limited it to these 5 things. And again, for the temporary protection order, it's about 2 weeks in length. If the petitioner does not come back to file or does not come back for their hearing for their civil protection order, the temporary protection order, this relief section does expire at the end of that 2-week period. So the first thing that can be granted in a temporary protection order is what's called a no-hats order. So this is the most bare bones type of protection order. It simply states that the respondent cannot harass, assault, threaten, or stalk the petitioner and their children. Occasionally we have survivors who come in who just want to send a warning signal to the respondent. They, at this point, aren't ready to put in some of these other types of relief. Maybe they still want to have contact with the respondent. Maybe they still want to be in a relationship. But they want to send a message that they have a second set of eyes looking at them, right? The courts are now paying attention to what's happening in this relationship. So survivors can come in and they can file for just a no-hats order. The second thing that could be granted in a temporary protection order is that the respondent may not contact the petitioner. And on the petition, if you take a look at it, you'll see that there are 3 checkboxes and then an other checkbox. So the checkboxes typically are the respondent cannot contact the petitioner in writing, by phone, or in any other manner, directly or indirectly through a third party. And what that third piece means, it's inclusive of everything from social media to sending messages through friends, any way that the respondent attempts to get in contact with the petitioner outside of those 2 initial in writing and or via the phone. The other piece, or there's an exceptions piece. So there is one nice thing about the protection order process in DC is that you can make it very tailorable to the needs of that particular survivor. So when survivors come in, they can also put exceptions to this rule. They can, especially our survivors who have children in common with the respondents that they're filing against, they may know that they're going to have contact, but they want to be specific about how that contact can happen. So they can be specific and they can stipulate the respondent can only text me Monday through Friday about our child in common. And if the respondent goes outside the boundaries of what they have dictated in that order, then that could be considered a violation of the protection order. So again, petitioners can check off any of those boxes, all of those boxes. They can also include exceptions if there are certain types of contact that they want the respondent to have access to. The third is a stay away, and on the petition, I believe it still says 100 feet. Very recently, it has been ruled that that 100 feet is now 100 yards. So the respondent must stay away from, and it could be everything from the petitioner themselves, they have to stay 100 yards away from. It includes the petitioner's children. It could be their home, their vehicle, their workplace, the children's school or daycare, which is a big one that we'll talk about in a few minutes. And they can list other places that they would like the respondent to stay away from. Often when I'm safety planning with survivors, I ask if they regularly go to any community centers or faith communities that the respondent may try to find them at. And they can include those locations as well in their protection order, so the respondent has to stay away from those places as well. A petitioner can also be granted temporary custody over children in common through the temporary protection order process. Custody in DC defaults to joint custody between parents. So this is a way that just in case the respondent wants to pick up the children from school as a way to regain power and control over the petitioner, the judge can grant temporary custody over those children in common to the petitioner. The last piece says that the respondent must vacate the residence. There are a couple of things that have to be true for this to be implemented. The first is that a respondent can be vacated from the residence if both parties, both the petitioner and the respondent, are listed on the petition, are listed on the lease agreement or the deed. So this is true for rentals or for home ownership. Both parties can be listed on the lease or deed. Then the judge can order the respondent to be vacated from the residence. If only the respondent's name is on the lease or deed, so the petitioner's name is not on the documents. If they are married, if the parties are married, and this is legal marriage because DC does not recognize common law marriage. If the parties are married, the judge can still order the respondent vacated from that home. If neither party's name is listed on a lease agreement, the vacate provision cannot be enacted. There has to be a lease agreement in order for this to be enacted. So again, the first, both parties' names are listed on the lease or deed. Then the petitioner can vacate the respondent. If the parties are married and the respondent's name is the only one on the lease or deed, the petitioner can still vacate the respondent. But if no parties are listed on any lease, then this piece cannot be enacted. So at that TPO hearing, the TPO can either be granted where the protections are enforceable but not punishable until the respondent has been served, or the TPO can be denied. I'm going to go back and talk about what does it mean when I say that protections are enforceable but not punishable. In order for a respondent to be held liable for what a judge has ordered, they have to be given a copy of the temporary protection order. They have to be served, they have to be notified that these protections are in place. But they are enforceable. I'm going to go back to the example of if there is a child in common and the petitioner requests that the respondent has to stay away from the school or daycare of the child in common. The petitioner can provide a copy of the protection order to the school. So most schools have front desks where if someone needs to check a child out from school, they have to go to the front desk. The petitioner can provide a copy of that protection order that states that respondent cannot come and pick that child up from school. The school can then enforce that order. They cannot allow that respondent to come and pick up the kid. But the respondent will not be held criminally liable. So we're going to talk about a violation of a protection order is a criminal offense. If they have not been served with that protection order, they cannot be held accountable to the criminal punishment that goes along with violating a protection order. And again, there are approximately 2 weeks between the date a petitioner files and the scheduled CPO hearing date. So if a TPO is denied, then there are no protections until that CPO hearing. Same thing goes for if someone comes in and files and they don't request a temporary protection order. None of those types of relief that we talked about just a few minutes ago are going to be applicable. So during that 2-week time period between when they file and they come back to court, those types of relief are not available. The respondent does not have to stay away from them. The respondent can still contact them. But if the respondent commits a crime, they can still call the police. So during the 2 weeks between when a petitioner files for a protection order and comes back for their civil protection order hearing, a few things have to be done. So the first thing that has to be done, as I just mentioned, is that the respondent has to be served. And for protection orders in DC, that involves in-person service. So there are typically 2 types of service that we default to. The first is self-service, which is a misnomer. And the second is Metropolitan Police Department service, or MPD service. Self-service, when a person files for a protection order, the clerk's office are going to give them a packet. And that packet of paperwork can be served to a respondent by anyone over the age of 18 who is not a party to the case. Meaning someone who is not getting protections within that protection order, someone who's not going to act as a witness in that protection order hearing. Anyone over the age of 18 can serve the respondent, meaning take that packet of papers and give it to the respondent. Now, good service in DC, we do not have to have the respondent sign anything. You don't have to watch the respondent read the documents. As long as they have adequate access to it. So we have had petitioners who they have had a friend run up to the respondent, toss it at their body, and then run away. As long as the respondent has access to get those papers, that's considered good service in DC. What does have to happen is the person who did the service, the person who gave that packet of papers to the respondent, has to fill out a form. And that form is called a return of service form. And that is the golden ticket when we're talking about the protection order process. So that form needs to be signed and dated by the person who did the service. And what's most important about that is, especially if there is a temporary protection order in place, that's when that temporary order goes from being enforceable to being punishable. Meaning if the respondent violates any of the pieces of relief that are granted in that temporary protection order, they can be held criminally liable. And we're going to talk about what the punishment is for a violation of a protection order in just a second. The second way that a respondent can be served is through the Metropolitan Police Department. MPD has a warrant squad that goes out Monday through Friday from about 6 a.m. until 2 p.m. It's important to note that there are only 2 officers that are actually in this department right now, and they're only generally going to attempt one time. They just don't have the ability at this point to attempt to serve protection orders multiple times, and those are important things that we need to talk about with the survivors that we work with. But MPD, they'll go out, they need to have a specific apartment or a specific location as to where to serve the respondent. Meaning if you know the apartment building, but you don't know the apartment number, the police aren't going to have the time to go and knock on all the different apartment doors. So you need to have a very specific address, including an apartment number, to get MPD to serve them at a residence. MPD can also serve them at their homes or at their workplaces as well. So if the survivor feels comfortable having them served at the workplace, that is also an option. There is another type of service where it's somewhat of a merging of the two. When we safety plan with survivors, sometimes we'll talk with them about having a self-service packet, but getting the police to actually do the service. And an example would be, we have a survivor who doesn't know the specific address of where her respondent stays, but know that he hangs out in a certain park, Friday afternoons with his friends. That survivor can go to the local police station, say, I have a protection order that needs to be served, accompany the police to where the respondent is, point out the respondent, and then the police can serve that paperwork to the respondent at that time. That police officer is still going to need to fill out that return of service form, but typically officers are going to submit it to the courts themselves. If a petitioner has a self-service packet and has a friend or family member do the service, they will need to bring that return of service with them to their CPO hearing. So again, there's self-service and MPD service. The important thing to note is that there needs to be a return of service form. That's the golden ticket that lets the courts know that the respondent has gotten adequate notice for the hearing, and it says who actually did the service, who was the person who gave the paperwork to the respondent. So once that's been served, if the respondent violates that temporary protection order, if there is a TPO in place and the respondent does something that they are not supposed to do, they can report that violation in one of 2 ways. They can report that violation by calling the police or going to a police station, or they can come to one of the 2 intake centers and file a motion for contempt. Again, for a lot of reasons, many of the survivors that we work with are not comfortable calling the police, so they can still file that motion for contempt in the courthouse where they filed that initial protection order. Also, during the next 2 weeks, they'll need to collect any evidence that they have, whether that's pictures, witnesses, medical bills, voicemails, anything that they have that can corroborate the allegations that they've listed in their petition with other types of evidence. It'll make their case stronger once they go to court. Also, during the next 2 weeks, if they're interested, they can get legal advice and information. Again, they don't need to have an attorney to get the order, but it can be helpful. And SAFE has about 12 different legal organizations that we work with that we can send referrals out for clients to get connected to a pro bono attorney. So many of our clients are interested in getting an attorney. I think right now about 60% of the clients who request an attorney get granted an attorney, get an attorney who's willing to pick up their case and represent them. But even if there is not an attorney who can represent them, they can still meet with an attorney and get legal advice about the process. So again, we talked about the 2 types of service. There's self-service, anyone over the age of 18 who's not a party to the case, and MPD service, the warrant squad that goes out Monday through Friday. So what is inside of a service packet? What is the respondent going to get a copy of? The first is they are going to get a copy of that petition. So they are going to get a copy of all of the allegations that the petitioner has listed against them. This is so that they have the opportunity to build a case to refute the claims in court if they would like to. The second is something that we call a NAHODA. It's a notice of hearing and to appear. So this is the form that dictates the time and the location of when the civil protection order hearing is going to be held. That way the respondent knows when and where they need to be for the CPO hearing. The third thing is that temporary protection order, if applicable. So if someone has filed for that temporary protection order, it will be included in that service packet as well. And the last thing that's in a service packet is that return of service form. That should not be given to the respondent. Again, that should be something that's signed and dated by the person who completed the service. So what is the punishment for violating a temporary or civil protection order? In D.C., the violation, it is a criminal offense, and it can have a punishment of 180 days in jail and or a $1,000 fine for each violation. Now, what's important to note is that the violation charge changes from jurisdiction to jurisdiction. But a protection order is valid in all jurisdictions. So if you get a protection order in D.C., it is applicable in every other state and territory in the United States. This is specific to U.S. It's not applicable internationally. What changes, though, is the violation punishment. So if someone violates a protection order in the district, the violation could be 180 days in jail and or $1,000 fine. That's different than if they violate it in Maryland or if they violate it in Virginia or anywhere else in the U.S. So the violation does change based on where the violation actually occurred. If a petitioner is moving to a new state or locality, they can register the protection order that they got granted in the district with the courthouse of their new home. That way the courts have a copy of the protection order that was granted, so in case something were to happen, they have that document with them in the courthouse, and the police in that jurisdiction will also have access to that document. The last piece is that a petitioner cannot be arrested for violating his or her own order, meaning that if a petitioner gets in contact with the respondent, they cannot be held accountable to this criminal violation. They cannot be held accountable to this 180 days in jail or $1,000 fine. It could hurt their case later on. The judge may look at that in a negative light and may take that as a reason as to why the petitioner does not fear for their safety, so may not grant that civil protection order, but they cannot be held criminally accountable. They will not get in trouble with the law if they violate their own protection order. So what types of relief are available in the civil protection order? The first few are the same ones that we see in the temporary protection order. So that no hats piece, no harassing, assaulting, threatening, or stalking the petitioner and their children. They can also include other people in that as well. So if they have a new partner and the respondent has threatened that new partner, they can include them in the protection order as well. That person would typically need to be present at the CPO hearing so that the judge can confirm that they want those protections. The second one is the stay away from the petitioner. Again, this is 100 yards. It can include the petitioner's home, the petitioner's children, their vehicle, the children's school or daycare. It's stay away from all of those places where the petitioner frequently goes. The no contact piece. Something that a judge can grant in a protection order is that the respondent has to attend different counseling programs. And we talked about the no hats order earlier, why someone might be interested in a no hats order. Another reason someone may be interested is that the only type of offender counseling for domestic violence that's available in Washington, D.C. right now is through the protection order process. So some survivors are in relationships with respondents, and the respondent actually wants counseling services. So they may come in, they may file a no hats order so that they can still be in a relationship with this respondent, but then they can request that respondent goes to domestic violence classes, and the judge can mandate them to go to domestic violence classes. So different types of treatments that are available that the judge can remand the respondent to go to include drug or alcohol treatment, domestic violence classes, parenting classes. They can also request that the respondent undergo a mental health evaluation. Another thing to note is that all of these treatment programs are run through CSOSA, which is Court Supervision and Offender Services Agency. That's the district's probation and parole office. So even if that respondent has never had a criminal history in the past, is not currently under the supervision of a probation or parole officer, if the judge remands them to any of these counseling programs, they will still have to go under urinalysis. They will still also have a CSO, or a court security officer. They will still have someone that they have to report to, even if the only type of supervision that they have is through this counseling. So for a lot of our survivors, they may want their abuser to go into domestic violence classes, but they know that their abuser is actively using substances. This is something that we would want to safety plan around, making sure that they understand that if the respondent tests positive when they go in to attend their counseling programs, there could be additional punishment for that from CSOSA, and safety planning around the possible increase in violence that might come from that punishment. The next piece is that the petitioner can request that the respondent pay them for damage to property or medical bills or any other bills that have been related to the violence that they caused. They can also ask for child support or spousal support for the year. So again, all of the different things that are present in the protection order, all of the types of relief that are present in the protection order are only valid for the duration of that protection order. So you can request, and the judge can grant child support or spousal support while the protection order is in place. Often we advocate that the survivors, if they want this to be a longer term order, file a separate order in family court, which is where child support, child custody, and divorce cases all take place. So again, all these pieces of relief, particularly the different types of financial support, the respondent only has to abide by that as long as the protection order is in place. The vacate the residence, again, we talked about that earlier. The petitioner can vacate the respondent from the shared residence. They can also determine custody and visitation for the duration of the order. So that child custody that we talked about in the temporary protection order can be extended for the duration of the civil protection order. And they can also negotiate a visitation schedule. So one option that they have is something called court-supervised visitation, meaning that the petitioner may want the respondent and the child to still have a relationship, but they don't feel safe having the respondent take the child back to their residence. So the petitioner can bring the child to the courthouse, the respondent can come to the courthouse, and they can have a supervised visit with a social worker that's present. That way the child can still meet with their parent, but there's an additional level of safety for that child as well as for that petitioner. The next thing is that the petitioner can ask for costs related to attorney's fees. So if they got a private attorney, they can request to be reimbursed for the fees that they paid. They can also ask for return of private property, particularly keys. They can ask that MPD stand by while the respondent gives over the keys that they have to the petitioner. The last thing is if you have a civil protection order granted against you, you cannot legally own a firearm. Now, this is a big point of contention, particularly for respondents who have jobs where a firearm is part of their job. So respondents who are in the military, who were police officers or special police officers, this can be a big problem for those groups because they very well could be put on desk duty or lose their jobs if they have a civil protection order taken out against them. And this is true for civil protection orders across the country. There is something called a work exemption, where a judge can state that the respondent can only have access to a firearm, but they have to check it out when they go into work and they have to check it back in at the end of the day. So again, the firearms piece is something that's across the nation, but there can be exceptions in there for respondents if they have to have a firearm for their jobs. So we finally get to the CPO hearing date. The first thing is all the parties are scheduled to arrive at 8:30 a.m. They don't stagger the arrival times. Everyone is showing up at the same time. And they're going to check in with the clerk of the court. The clerk is going to be standing at a podium between courtrooms 113 and 114. These are the two courtrooms that exclusively hear different types of protection order related cases. Another thing to note is that civil protection order courtrooms are open to the public, meaning that the respondent can bring friends, they can bring family, and this happens very frequently where they bring people with them in order to intimidate the petitioner. It also means that the petitioner can bring support systems with them. So if they have a friend or a family member who would be a great support for them in the courtroom, they can bring that person and that person can accompany them to CPO court. It also means that the petitioner and the respondent will be talking about the allegations in front of a room of people. So preparing that survivor for having to recount things that they documented in their protection order in front of people that they may not know is something that's really important to the safety plan. So we're now going to talk about outcomes of the cases. So what happens when some parties or no parties show up? What happens in the court case? So the first thing is, if no parties appear, if neither the petitioner nor the respondent come to court, the case is going to be dismissed. Same thing, if the respondent is the only person who appears, the case is going to be dismissed. Now, there are two types of dismissals that can happen. The first and the most common is something called dismissed without prejudice. We call it DWOPT. This means that the petitioner can use those same allegations that they filed using to refile again at a later date. Nothing new has to have happened. They can use those same incidences that they listed to refile for a new protection order. And typically in court, what we hear is that the judge will state that it's dismissed for failure of want of prosecution. The petitioner did not show up to court and no one wanted to prosecute the case, so they're dismissing it. This is the most common type of dismissal. This is what the vast majority of the cases that are dismissed, it's DWOPT, it's dismissed without prejudice. There is something called dismissed with prejudice. This means that the petitioner cannot use those allegations that they listed in that petition to refile again. Meaning if they wanted to come back and file for a new protection order, there would have to be new allegations that they're presenting for the court to consider that new petition. As you can imagine, for the case of domestic violence, a lot of domestic violence cases are built on this pattern of power and control. So having that historical evidence can be very important. And luckily, judges in D.C. utilize this very infrequently. I think it was 7 or 8 times last year. They're really only doing it when they believe that the petitioner is misusing the resources of the court. So if the petitioner has filed on these same allegations multiple times and has never shown up to court, the judge may then dismiss it with prejudice. But again, very infrequently, but it is important to note just in case you were to ever come across that. So if only the petitioner appears and the respondent was not served, so the petitioner comes to court, but they were unable to serve the respondent either through police service or through self-service, a couple of different things can happen. The first is that the petitioner can request a continuance. So the continuance will allow the petitioner an additional 2 weeks to serve the respondent. So they'll issue a new court date, generally about 2 weeks after that initial CPO hearing date. If there's a temporary protection order in place, they can extend that temporary protection order until the next court hearing. And then the petitioner has another 2 weeks to try and find and serve that respondent. The second thing is if the petitioner doesn't want to try and come back to court, then they can dismiss the case. So the petitioner can, just state that if something were to happen, they can come back and refile later. So they can dismiss the cases in person as well. If the petitioner appears and the respondent was served, so they have that return of service form filled out either by someone who did self-service or from MPD, the judge can go ahead and issue a CPO in the respondent's absence if they find that there's a reasonable belief that harm occurred. So again, that judge is going to make sure that those 3 pieces are still true, that there is an inter-family relationship, that a crime has happened, and that there is jurisdiction. And they can grant what's called a default CPO. With that default CPO, they will also issue a bench warrant. So a bench warrant is not an active arrest warrant. No one's going to be actively searching for the respondent, But if that respondent is to come into contact with the police in any other way, so they're stopped for a traffic violation or they come into court to file something on their own, what will happen is that respondent will be taken into custody. They'll be held overnight or until the next day that the courts are open. Then they will be served with that default CPO in open court. The last thing to note about default CPOs is that until the respondent has been served with that default CPO, they can't be held accountable to the different types of relief in that CPO. But that temporary protection order, if applicable, so if they were served and they were served with that temporary protection order, that temporary order will be extended until the respondent is served with that default CPO. So the survivor can still have protections put into place until that respondent is served with that default order. Upon being served with that order, so once a respondent has been found and has been served with that CPO, they have approximately 10 days to file to try and get that order vacated. If they believe that they had not been adequately served, then they do have 10 days to refute the allegation that they had been served. So if both parties appear, if both the petitioner and the respondent come, the first thing that's going to happen is that they're individually going to meet with someone called the attorney negotiator. Now, if they have legal representation, that legal representation can also go into the meetings with the attorney negotiator as well. They'll start with the petitioner, and they're going to review the requests that the petitioner had listed in that petition for the protection order. They will then see if there's anything that the petitioner is willing to negotiate on. Because at that point, they're going to send the petitioner out of the room, and they're going to bring the respondent into the room. And ultimately, the attorney negotiator is trying to come to an agreement between the two parties, either to have the case dismissed or to have the respondent agree to the terms of the protection order. So the negotiator is then going to go through the request that the petitioner had and see if the respondent is willing to comply with those orders. At that point, they're going to go back and forth until either they're able to come to a conclusion and a negotiation or they're unable to. So if they're unable to come to an agreement, there will be a hearing held in front of a judge, and that's called a contested hearing. That's where they're going to need to have their witnesses ready. They're going to have to provide testimony themselves. They can present any evidence as shown. If they are able to come to a conclusion, then they can go ahead and say that the respondent is going to consent either with or without admissions, meaning that the respondent will state that, yes, I will abide by the terms of this protection order, but I do not admit that I committed any of the alleged crimes in this order. That's consenting without admissions. Or they can consent with admissions. They can state, yes, I will abide by the terms of this order, and yes, I committed the crimes that are listed in this order. Typically, we don't see a lot of respondents stating that, yes, they did commit those crimes. We don't see a lot of consents with admissions. Typically, the only time we're going to see that is if there is a corresponding criminal case and they've already been found guilty of that crime. So again, through that attorney negotiator process, the respondent can go ahead and consent to the protection order, and there doesn't have to be a full hearing. But if they are unable to come to a decision, that is when they're going to have a full hearing. And hearings can last as little as an hour or can be as long as I've seen 3 days. And at the end of that hearing, the judge is then going to make a decision. They're either going to grant that protection order or they're going to deny that protection order. Once that protection order is in place, it is then enforceable for the next calendar year. If that protection order is denied, they cannot use those same allegations to try and refile. There has been a judicial decision made on those allegations. So if they wanted to refile, they would have to use new allegations. There is an organization that does appellate work. So if someone believes that their protection order was denied without good cause, we can connect them to a group called DV Leap. And that group does appeals work. So they can assist survivors in appealing CPO cases. So during the course of that year, things can change. So if a petitioner needs to change any of the things in that petition, they can always come back to one of the 2 intake centers and file different motions. The first is that they can come and file a motion to modify the order, meaning either they want to change some of the types of relief that they requested initially, and that could be to add new types of relief. An example would be When we have petitioners who are pregnant, they can't ask for custody until that child is born. So if the petitioner is pregnant when they get granted the protection order, once that child is born, they can come back and then request custody of that child through the protection order process. And that would be a motion to modify the order. Petitioners can also add additional incidences to the petition, so they can come back and amend it. This is particularly true in the temporary protection order to civil protection order process. If maybe in the initial drafting of the petition, they didn't include all of the incidences that they wanted to, either because of time constraints or because they just didn't have the ability to think through all of those different incidences that had happened at that time, they can come back and they can file a motion to amend, where they add additional incidences to the descriptions within the protection order. A protection order can also be vacated, which means removed, before its expiration date. Now, either party, the petitioner or the respondent, can request for an order to be vacated, but it has to be done through the court process. If a petitioner and a respondent reconcile and they do not go through the court process, that respondent can still be held accountable to violating that protection order, even if they have reconciled with the petitioner. So there does have to be a motion to vacate the order to get rid of the protections that are in place. There also has to be a new hearing. So all of these, in addition to just filing the documentation, there has to be new service and a new hearing for any of these changes. Again, so the order is in full effect until it is removed by a judge or until it expires at the end of the year that the CPO is in place or at the end of the 2 weeks that the TPO is in place. So petitioners do have the right to request that their CPOs be extended for an additional year. They will need to come into one of the 2 intake centers and file a motion to extend at least 2 weeks before the order is set to expire, because again, they're going to have to set a court date to address that extension request. And the judge will ultimately assess and determine if there is good cause to extend that CPO. So we've gone through the entire protection order process. You should have a review sheet, and if you haven't been keeping track as you've been going through, go through and fill out the review sheet. Make sure you answer all of the questions.